Hello, and welcome to this introduction to Section 504. What is Section 504? Section 504 is a federal civil rights law under the Rehabilitation Act of 1973. In 2009, the ADA Amendments Act became law and broadened the interpretation of Section 504. Students with disabilities in school settings fall under the civil rights protection of Section 504. The law and regulations prohibit discrimination on the basis of disability in all school programs and activities in public schools receiving direct or indirect federal funding. It is designed to provide equal access and fairness in general education to students with disabilities through their 504 accommodation plan. What is considered a disability? The ADA's current definition of disability means, with respect to a person, a physical or mental impairment that substantially limits one or more major life activities, a record of such an impairment, or being regarded as having such an impairment. Unlike IDEA, there are no official categories for disabilities under Section 504. Here I have listed some examples of disabilities that are often accommodated. This is not an exhaustive list, and students do not need an official diagnosis for one of these disabilities to qualify and to receive accommodations under Section 504. Child find is a legal requirement included in the Individuals with Disabilities Education Act and Section 504 that requires schools to identify, locate, and evaluate all children who have disabilities and who may be entitled to special education or accommodations provided under Section 504. Every student with disabilities should have equal access to a free, appropriate public education, the same as any other student without disabilities. There are risk factors that all educators should look for that may indicate the need for a student to be referred for an evaluation for special education or Section 504 eligibility. Some of these risk factors could include, but are not limited to, when a student is evaluated and does not qualify for special education services under IDEA, they may qualify under Section 504. When a parent frequently expresses a concern about the student's performance. When a suspension or expulsion is being considered for a student. When retention is being considered. When a student shows a pattern of inattention or not benefiting from classroom instruction. When a student returns to school after a serious illness or injury. When a student exhibits a chronic health condition. When a student has been identified as having attention deficit disorder or attention deficit hyperactivity disorder. When substance abuse is an issue. When a disability of any kind is known, suspected, or the student has a record of an impairment. When a student shows a pattern of not benefiting from classroom instruction or continual failing grades. When it is known that the child is taking medication. When it is discovered that the child is seeing an outside counselor, therapist, or physician. Or when signs of anxiety, depression, withdrawal, or a mental health diagnosis are discovered. Who is eligible under Section 504? A student is eligible for a Section 504 accommodation plan if an evaluation shows that the student has a mental or physical impairment that substantially limits one or more major life activities. So what are major life activities? Here are some examples of major life activities that are commonly limited for students who qualify under Section 504. This is not an exhaustive list. What is the evaluation process for Section 504? To initiate an evaluation, a referral is made by a person. Typically, these referrals are made by a parent, guardian, or educator who is familiar with the student. This referral can be made verbally or in writing. A school must obtain written parent or guardian consent prior to conducting an evaluation and provide the parent or guardian with their procedural safeguards, which outlines the rights of parents and guardians and their child with a disability and, at the same time, give families and school systems several mechanisms by which to resolve their disputes. Once the school receives consent, they will assemble a team of individuals who are knowledgeable of the student in order to conduct the evaluation and determine eligibility. The 504 team reviews all available evidence to determine eligibility under Section 504. If the team determines that the student is eligible under Section 504, they must discuss any accommodations that the student needs to provide the student with equitable access to education. If an eligible student requires accommodations to access education, the accommodations and services should be recorded into a Section 504 accommodation plan. School districts violate Section 504 when they deny or delay in conducting a formal evaluation of a student when it would have been reasonable for a staff member to have suspected that a student has a disability and needs accommodations under Section 504. What is in a Section 504 accommodation plan? A Section 504 accommodation plan differs from an individualized education plan, or IEP. The IEP includes specialized instruction and requires documentation of measurable growth. The Section 504 accommodation plan should provide personalized accommodations based on student needs that provides equal access to public education and services. Here are some examples of accommodations that are often included in Section 504 accommodation plans. Section 504 plans should be personalized to meet the individual needs of a student. 504 teams should take care to ensure they do not over-accommodate students. A well-constructed Section 504 plan will provide accommodations that remove existing barriers that prevent students with disabilities from accessing equal opportunities in their education as compared to their peers who are without disabilities. Once a plan is established, you must provide the information to every individual who will be providing the accommodations. 504 plans must remain confidential and only be shared with individuals who will be directly serving the student. It is important to ensure that these individuals understand the accommodations in the plan and stress to each individual that the accommodations need to be provided with fidelity. Pay close attention to semester changes, any schedule changes throughout the year, any staff changes, and always provide substitutes with the 504 plan. It is beneficial to review 504 plans annually and make any necessary adjustments. Adjustments to 504 plans can be adjusted at any time when necessary. Just remember that the changes will need to be made by a 504 team. There are some key considerations in the application of Section 504 in education. It is important to note that response to intervention, or RTI, is not required prior to initiating a Section 504 plan evaluation. A wait-and-see approach is highly discouraged when there is substantial evidence of a disability. Once a referral for evaluation is received, the school should take action and evaluate the student. Interventions can take place and are encouraged during the evaluation process. A common misunderstanding is that when a parent or guardian provides documentation from an outside healthcare provider, the student will automatically qualify under Section 504. This is not true. For a student to qualify under Section 504, the 504 team must consider multiple sources of evidence. In addition, a school cannot require a medical diagnosis or official paperwork in order to qualify a student for Section 504. Some students do not have access to health care, and it would be considered discrimination to qualify one student with disabilities for Section 504 over another due to limited resources. Remember, this is a discrimination law. All students have a right to receive a free, appropriate public education, regardless of their economic status or other personal barriers. Regarding evaluation, once an evaluation is initiated, Utah law requires that an eligibility determination needs to be established within 45 days. The 504 team must consist of individuals who are knowledgeable of the student. And Section 504 applies to any school-sponsored activity, which includes extracurricular activities. Thank you for joining me for this brief overview of the Section 504 Federal Civil Rights Law under the Rehabilitation Act of 1973. If you have questions or concerns about the law and how it applies in your district or charter school, you may contact your Section 504 coordinator. Every district or charter school is required by law to have a Section 504 coordinator. You may also refer to the Office for Civil Rights. They offer many resources and a process for filing an informal or formal complaint. There are also resources available on the Utah State Board of Education Educational Equity webpage. The Utah State Board of Education is a neutral body that can provide families, educators, and other stakeholders with technical assistance. Thank you for everything you do to help identify, locate, and evaluate every student in Utah with a disability who may need accommodations that provide them with equitable access to public education.